Our last panelist is going to talk about essentially her last hope and out. It's a reality for many businesses, even in the best of times, and something that exists because it's necessary and frankly quite normal. If this is something that you in our audience is possibly faced with, we know that as an entrepreneur, though, you will be back. But in the meantime, please listen carefully to what Phil Strok has to say on this important and final subject. Phil is a partner with the law firm of Smiley, Wang Ekvall, LLP, concentrating his practice in the areas of bankruptcy, insolvency matters, and business reorganizations. He has experience representing Chapter 11 debtors, trustees, secured and unsecured creditors, creditors' committees, asset purchasers, and other parties in the context of bankruptcy cases, out-of-court workouts, and assignments for the benefit of creditors. His representative industries include real estate, construction, apparel, healthcare, manufacturing, transportation, restaurant and food service, telecommunication, and retail. Phil, as you take us home, I'm going to pull you up here, get you spotlighted. I think we all need to know about, bankruptcy, and does that remain a viable option for distressed small businesses during the coronavirus crisis?
Absolutely, Rich. The bankruptcy courts are open for business, even if it's just telephonically right now. But before you get to that, and we advise our clients that bankruptcy is a last resort solution after the business has explored and exhausted all of its other opportunities and alternatives. The business should communicate with its lenders, landlords, key vendors, and creditors, and try to reach an out-of-court workout if at all possible. And the climate we have today is ripe for out-of-court workouts, given that most of the people involved in these disputes and situations are innocent victims here. The business should explore all of its sources of financing and cash, including from its existing lenders, other lenders, or, as we heard today, from the stimulus packages that are available, or any other relief that becomes available in the near future. But if everything fails, then bankruptcy may be the only option. If you've got a business that's basically dead on arrival and there's no hope of resuscitation, then you're looking at a Chapter 7, which is a liquidation and a sale of all the assets of that business. But when the core business plan is sound, a company and a business may consider a Chapter 11 bankruptcy where they try to reorganize and restructure their debts and liabilities.
So what are the advantages and in contrast, the disadvantages of bankruptcy?
Sure. Well, there's three highlighted advantages that I'll go through. First of all, when there's a bankruptcy filing, it stays virtually all enforcement actions against the business and its assets. It gives an automatic stay, which allows the business a breathing spell in order to facilitate a reorganization or restructure of its business and financial affairs. The second advantage is debts owed to creditors can be reduced or paid over time, even without the creditor's consent. And that's a huge advantage of a bankruptcy. And finally, the last advantage is that the bankruptcy code allows businesses to shed or get rid of unprofitable leases and contracts through a process known as rejection. Well, there's always disadvantages to a bankruptcy. Okay. And the first disadvantage is that once you go in, you can't necessarily get out. It's not really up to you once you file and things aren't going the way you want them to. You can't just get out of the bankruptcy case. It's not a two-way street. Second disadvantage is it's expensive. A Chapter 7 liquidation may be relatively inexpensive, but a Chapter 11 reorganization could be quite expensive. Third disadvantage is it's time-consuming and very labor-intensive. The fourth disadvantage is that it's a huge drain on management resources, and it's very distracting. Management has to spend almost full time working just on the bankruptcy process itself. And finally, the last disadvantage is even with good counsel and advice and serious pre-planning, there's no guarantee that a Chapter 11 will be successful in the long run.
So, a lot of small business owners wind up in a situation where they're personally guaranteeing business debts. Is bankruptcy still an option for the business in those scenarios?
Yes, it's still an option. What we're really talking about here is the question of if the business files for bankruptcy, what happens to the personally guaranteed debt? And the answer to that question is the business bankruptcy does not extinguish the owner's liability on the guarantee, nor does it give that owner the protection of the automatic stay. So collection efforts against the owner will continue, notwithstanding a bankruptcy of the business itself. And that's one of the reasons that a lot of owners will concurrently file their own individual bankruptcies at the same time the business files. We saw this a lot during the last recession with real estate developers who had guaranteed all the debts of the business, and they had to file their own personal bankruptcies as well.
Wow. Okay. And then last thing I wanted to ask you is you alluded a little bit to the stimulus package as, one place that might be helpful. And if it weren't, and there was still, need for access to bankruptcy, has the stimulus provided greater access for distressed small businesses to get into bankruptcy and find that protection?
It has. And let me just step back a little. Before we even had the COVID-19 pandemic, we had just enacted a new Small Business Reorganization Act in February of this year. It's a very favorable bankruptcy provision for small businesses that allows them to reorganize quicker and cheaper than ever. The problem is the threshold for businesses to take advantage of this provision are not high enough. They were originally, if you had debts, secured and unsecured, of 2.7 approximately or less, then you would be considered a small business. Now, the CARES Act has provided a significant benefit, is that threshold limit for small businesses to take advantage of the Small Business Act has been increased to $7.5 million, and that will greatly expand the availability of these favorable provisions for small businesses. Now, I do want to mention that provision sunsets after 1 year, so it's only available for a 1 year period.
Got it. Well, listen, thank you. Hopefully, those of you that are listening where this is a need, you got some valuable information there as well as or I should say, just like all the rest of us have. That was quite a discussion. And we've taken a little bit longer than I think we had hoped to. And I want to thank all of you for the time you did take to help those that we serve stay informed and on top of what is happening around the world. Before we